And welcome everybody to the 13th edition of the Deserve to Win podcast, coming at you for the first time from our brand new Troutman Amin LLP West Coast podcast studio. As always, I'm your host, Eric J. Troutman, the czar of the TCPA. Although I think I'm less the host than the co-host these days. The co-host with the most. Queenie, you're kind of co-hosting now, right?
Hi, folks. I am Eric's co-host, better known as Queenie, and I am partner now at Troutman Amin LLP.
This is really exciting.
This is to be back. Thank you.
Great.
Happy to be here.
We took about a month off. Actually, it's been 2 months. We took a little while off because we were moving into our new space here at the Spectrum Center in Irvine, which is it's a fantastic space. It's really cool. So we were trying to set up our new studio. We were trying to get moved in. So we took a little time off. Thank you so much for bearing with us. I know we've had a ravenous audience. So many of you have reached out and said, when's our next episode of Deserve to Win? Well, here it is, okay? We love you. We were never going to leave you hanging. But why don't we introduce ourselves? I know Pooja and I already have. Who is the lovely redhead all the way to the right?
My name is Tori Guidry. I am the dame of TCPAWorld and an attorney at Troutman Amin LLP.
Very good, fantastic. And to my left?
Hi guys, I'm Brittany Andres, aka the Baroness, and I am an attorney at Troutman Amin.
Love to have the Baroness and the Dame along with us. This is fantastic. So we've got so much big news to discuss. I mean, we're going to talk about TCPA because we always do. Before we get there, though, please just indulge us momentarily because, again, it's been 2 months since we've been together, and a couple of things have changed. One, as we've discussed, we've moved into our new office space, which is really cool. Of course, we've become Troutman Amin LLP, which is kind of a small change. I mean, that's a little different. And we've opened up another office now, right? In the Big Easy of all places. Am I saying this right, Tori? Is it New Orleans? Like, how do you pronounce
New Orleans.
New Orleans? No. New Orleans?
We should do a video on how to pronounce New Orleans.
Oh, and then the ladies did a video on how to pronounce Troutman Amin because in the absence of having the Deserve to Win podcast, people are taken to calling it like Troutman Amin or something ridiculous, which we had to fix. Amen. So thank you, ladies, for repairing the damage. That was just really bad. And we've got even more big news, which is probably by the time this podcast has come out, we would have had our first ever conference, the Summer Marketing Law Conference, which is going to be incredibly well attended. It's completely sold out. I mean, literally, people are going to be squeezed into this, like standing room only, like sardines. I actually feel pretty bad. I mean, like literally, people are not going to have seats. And we've got a virtual option that people will be attending. We've got dozens and dozens of people signed up for that. The biggest brands in the country, like all these huge companies are sending their legal staff to attend our conference. It's amazing. I mean, it really is remarkable what we've been able to accomplish in like such a short amount of time.
Well, you're forgetting the most important change.
Which is what?
We have a merch store.
Oh, yes, that's a good point. But we're calling it a swag store, to be clear. And ironically, none of us are wearing any of the swag. So great job merchandising, Troutman Amin. Good job. But indeed, you can go to troutmanamin.com/swag and check out our fine assortment of merchandise, branded apparel for your lifestyle needs, right? That's how we're here. But okay, that was a ton of fun, but now let's get to work, okay? There's been a huge number of developments over the last 2 months, of course. We know that the comment period on the FCC's NPRM regarding closing the lead generation loophole is now completely closed. That means that the written comment period is over. There's still an opportunity to have what's called ex parte meetings with the FCC, where you, yes you, can sit down and have quick meetings over there and help them to understand why essentially saying that you can only have consent go directly from a consumer to a brand might be very damaging to your business. If this is something that's going to hurt you, then do feel free to reach out. But understand that right now the 28 AGs have in fact weighed in with the FCC, asking them to adopt the public knowledge proposal, which is based on, in my opinion, a complete misread of the statute. That is actually not the statute itself, but the CFR that implements the TCPA. But they are saying essentially to the FCC, 28 AGs and public knowledge and the NCLC, very powerful organizations, are all weighing in and saying the same thing. They're saying, dear FCC, you cannot transfer consent. Consent has to be provided directly from that consumer to that brand with no intermediaries, and of course that could be the death knell for tens of thousands of small businesses that are in the lead generation industry, as well as the end of comparison shopping online. really high stakes here. Of course, REACH, the Responsible Enterprises Against Consumer Harassment, the organization that I am the president of, has weighed in with very heavy-hitting comments, both on the initial side and in the reply side. But unfortunately, and I do mean this, I mean this is unfortunate, REACH is the only comment to have taken the legal position, the doctrinal statutory interpretation position of public knowledge and NCLC, and take it head on and rebut it. And don't get me wrong, we are incredibly powerful and ultimately we are right, but when you only have one voice taking a position and there's very powerful opposition, it gets to be very challenging to assure a policy change. So look, I'm starting to brace for bad news. And as I sit here talking with you folks, again, we're probably months from a ruling, but really, it is something that you need to be thinking about. How do we pivot? How do you move forward in an environment where, in fact, intermediary lead transfers may no longer be a thing, say, come October or November? It's something to really start thinking about. And I know at our summer conference, Pooja, we're going to be looking into those issues. But moving off of that, I just wanted to give a quick update because I feel like I owed that to everybody. There's been a few pretty interesting developments. I think the most interesting one is the Ninth Circuit just last week has held that you have statutory standing. This is, Article 3 constitutional standing. This is crazy. To me, this is crazy. If you put your phone number, right, on the national DNC list, even if you let somebody else use your phone, right, you're not even using your phone. You're hanging out, you're at the office, and your kid is using your phone at home, and the kid receives a text message. You, even though you're a dozen miles away at the office and never even received that message, you have standing to sue for that message that you never received merely because you're the subscriber and because you're the one that put your phone number onto the national DNC. I think that's a crazy ruling. If you dig in, actually, the case is Hall versus Smosh.com. If you actually take a look at the Ninth Circuit ruling, though, it's fascinating because the Ninth Circuit panel frames out the rule like, hey, it doesn't matter if you're using the phone or not. If you put your number on the DNC, you've got standing anytime a text message is sent without the required level of consent. That's the holding as framed. But if you look at the analysis, actually in the complaint, the plaintiff had pleaded that she actually received the text message. So the analysis was, if you allege that you received the text message, that's all that's required, right? Which I agree with. If you receive the text message, what's the issue? Obviously, there's going to be standing there under Van Patten. Yet the Ninth Circuit used incredibly broad, incredibly loose language to kind of use that very narrow fact pattern to fashion a broader ruling that gives standing to any subscriber that's ever put their phone number on the DNC. I think that's a remarkable overstatement of the law, but it really shows the further commitment of the Ninth Circuit to increasingly broad statutory and constitutional standing around the TCPA during a time frame when the 11th Circuit is doing the opposite, right? Looking at every opportunity to constrict. And so you kind of got this micro Florida versus California, right? DeSantis versus Newsom kind of thing playing out in the TCPA world. Always a good time. But the thing I like about this ruling, there is one thing I like about it, which is the Smosh.com actually specializes allegedly, like I don't know if this is true or not, allegedly in sending text messages to teenagers. Apparently they sell kind of something that teenagers, I don't even know. It could be apparel. It could, like it's Smosh.com, so I want to say it's like green slime from like Nickelodeon or something. But honestly, I don't know. They sell something and they send text messages primarily to teenagers. And at the lower court, the plaintiff argued that this is essentially statutory rape, right? That a teenager can't consent. If you can't consent to, you can't consent to receive robocalls either, right? That's the theory, which on the one hand, kind of makes sense in a weird way, that you could statutorily rape a cell phone, right? That is the argument that the plaintiffs are making. Fascinating, fascinating argument. We were denied a ruling on it, though, because the lower court punted on standing grounds, right? That's why it ended up on appeal. But now the appellate court said, no, you don't get to punt, district court. You have to now answer the ultimate question of, can you consent as a child, as somebody under 18, a minor, to receive robocalls? Really fascinating. I'm dying to see what the answer to that's going to be. I think it's really interesting. I think the ultimate ruling is going to have pretty broad ramifications because everybody from time to time, right, is going to be calling somebody who's under 18, and are you automatically liable for that? We're going to find out. We don't know yet. We're going to find out. So that's my report. Hopefully you all found that interesting. Tori, why don't we throw it over to you? What do you have for us, Dame?
So On, I believe, the 28th of June, there was probably the biggest lawsuit ever filed.
Small statement.
Well, and it is a CIPA claim against OpenAI and Microsoft. And as you know, CIPA is $5,000 per violation. They're claiming these 16 plaintiffs, along with an entire class, there's several different classes named here, that OpenAI has been illegally stealing information off the internet by scraping it from sites like Reddit, Instagram, Spotify, etc., anything that's using OpenAI technology. So now they're facing possibly a death blow to the company, even as big as Microsoft, with likely $1 trillion worth of liability here.
So the CIPA is, of course, the California Invasion of Privacy Act. And as you correctly identify, there's $5,000 penalties available. What it prohibits in this context, though, is attempting to learn or read the contents of communications while they're in transit or at the time of transit or at the time of receipt. And importantly, internet communications, that is web session activity between browsers and web servers, are treated as communications for purposes of CIPA. And so what this new OpenAI case, which is brought by anonymous individuals who appear only by their initials, so PM versus OpenAI is the name of the case. What it's alleging is essentially that both OpenAI and ChatGPT and Microsoft were working together to allow real-time reading of chat communications, right, using a bunch of popular applications, and that essentially this happened millions of times, and that they were taking these consumer interactions and they were feeding it into their AI to train it, right? That's what this is all about, right? You see generative AI, we see how powerful a tool something like ChatGPT is. Well, this lawsuit's alleging that all of this is built upon the backbone of illegal eavesdropping. Right? And you can just kind of sit back and think to yourself, wow, that kind of makes sense from a certain perspective. Now, I don't know if it's true or not, but if these allegations do turn out to be true, as Tori correctly identified, this could be the largest lawsuit of all time. Because if you're talking about millions of individuals whose communications were eavesdropped on day in, day out at $5,000, right, per wiretap, per eavesdrop, I mean, you're talking about trillions of dollars at stake in this case. And it just goes to show you how powerful the California Invasion of Privacy Act, the CIPA, really can be when you're talking about communications taking place, interactions taking place over the internet. It's remarkable. And I know, Tori, at the big marketing law conference here, just next week, you're going to be handling the AI piece. I'm really looking forward to it. I think it's going to be great. So anything else on that?
That's all from me.
All right, Queenie, you're sitting here looking pretty quiet. What do you have?
Oh man, what do I want to talk about today? I'll probably talk about the other big sister statue of the FITSA, OTSA. I know you prohibited me from calling it the OTSA, but the Oklahoma Telemarketing Statute.
I actually prohibited you from calling it the FITSA.
The FITSA, got it. So FITSA, OTSA. So now I can say OTSA. See, I'm getting them confused. So we haven't spoken 2 months now, but the FITSA has been amended, which is pretty good news so far for many folks who are getting sued under the Florida statute. However, OTSA now, OTSA, if you recall, has been, it went into effect back in November of last year. And there wasn't that many filings in the first few months. However, in the last 2 months, we've been seeing a huge uptick and a pouring in of these OTSA filings, similar to how we did when the Florida statute first came out. One of the first cases was Wellco, Strader versus Wellco, and it had to do with the typical text messaging, the club cases, trying to give discounts. And the fact patterns were very similar to how the initial FITSA cases started coming out, so they're tracking in a similar manner. But other than bringing just the ATDS allegations under OTSA, they're also bringing the time restriction and how many calls you can make. So under OTSA, if you recall, there's 3 call attempts within a 24-hour period, like the FITSA. There's a more restrictive definition than the federal statute of the ATDS definition. And then additionally, there's also time restrictions. So, these plaintiffs' attorneys are bringing different classes underneath OTSA, similar to exactly how FITSA started and how the wave of FITSA litigation had begun. So just something to keep in mind. It's most of these cases are being filed in state court, and then they're being removed into the federal court, just a similar procedural pattern that's happening here. So, we predicted this on TCPAWorld.com a few months ago. The Duchess and I have been breaking it down religiously, really, for the mini TCPAs that keep coming out. So just another reminder, keep these state laws in mind. They're crucial, and the litigation is coming in pretty quickly. With that, additionally, there is a new amendment to the Connecticut telemarketing statute as well. And this one's just, it's so interesting. There's a few amendments here that are pretty critical. One of the main ones that a lot of folks are focusing on is the requirement of a caller to, within 10 seconds, give certain disclosures. Other than the identity and the purpose of the call, you also, within 10 seconds, have to ask the consumer, would you like to remain on this call? Would you like this call to end? And/or would you like to be placed on the internal DNC list?
That's bizarre.
Bizarre. Completely bizarre. And so, in the event that they do ask to be put on the DNC, there's additional requirements then that you have to abide by, and one of those also include stopping to call any number that belongs to the consumer.
Oh, yes.
So now, how are you supposed to know whether a consumer has additional phone numbers, right? These are things that companies should start thinking about, maybe training your agents to tell them, are there additional numbers that we can place on the DNC list? Just kind of getting your agents trained to kind of ask those questions if you don't already have that data in-house. It's a very broad statute. We don't know what's going to happen there. Then more importantly, the Connecticut statute also amended their definition of an unsolicited telephone call to include text messages now. So text messages now are explicitly covered under the definition. And then additionally, they have a more restrictive time restraint now. So now they moved it up an hour to 8 p.m. 8 a.m. to 8 p.m. is your call time restriction in Connecticut now. And then even moreover, you have this requirement where unsolicited text messages can't be sent at all at any time. So only the telephone calls can be sent between 8 a.m. and 8 p.m. Pre-recorded calls, faxes, and text messages, however, can never be sent.
That's incredibly important, that last piece to keep in mind, right? Under the federal law, of course, if you're sending a text message not using an ATDS and the number is not on the DNC, you can still send those manual marketing unsolicited messages. That is legal at the federal level, but the entire state of Connecticut essentially just got put onto the national DNC.
Yep.
You cannot send messages to the state of Connecticut, and of course you're going to look at area codes and zip codes in order to know that. These state laws are moving fast.
They're moving fast, and they're so nuanced. And actually, in the amendment itself, Eric, it mentions that the Connecticut DNC list is going to track the federal DNC list. So they're telling you, they're laying it out right there. If you read the underlines and the insertions, it is very clear what Connecticut's trying to do, and a large part of that is to prevent unsolicited text messages, and additionally, getting really strict on the definitions of what an unsolicited means and the time restrictions, and just, they're really nailing down. So it'll be interesting to see if Connecticut follows Oklahoma and Florida, or what kind of litigation will be driving. And yes, there is a private right of action, for those who are wondering.
Perfect. Why wouldn't there be? Now, you mentioned at the top of that segment that there's been a major amendment to the Florida Telephone Solicitation Act, the FTSA. Nobody calls it FITSA. But we don't have time to talk about that. But there has been major amendments. We'll talk about that in the next show. It's all good news for callers, and there's resources on TCPA World if you just can't wait until our next show. But for right now, why don't we throw it over to my dear friend, the Baroness. What do you got?
So there are a huge new wave of SIPA cases
back
filing.
to SIPA.
Yeah, and we're keeping up with them. We have TCPAWorld now, so we are blogging every case as we see them. So if you forget to catch up one day, be sure to check our blog out. But I do have a case, Tyrone Hazel versus Prudential Financial. To give a bit of context, Prudential Financial is an online web platform that provides consumers with life insurance quotes. So if you go to their website, fill out your information, you could obtain a life insurance quote. Prudential Financial partners with Active Prospect, and they utilize one of Active Prospect's products, which is Trusted Form. As I'm sure you folks know, a lot of businesses use Trusted Form to aid their business in verifying the consumer visited their website and to document consent, which is very important when you're hit with the TCPA demand, right? Of course, you want to prove you have consent and or the consumer visited your website. So plaintiff Tyrone Hazel and a group of plaintiffs sued Prudential Financial for violations of California Invasion of Privacy Act under the wiretapping provisions, basically saying that Active Prospect was wiretapping their internet communications. In response to the complaint, Prudential Financial argued that the plaintiffs failed to plausibly plead that Active Prospect was a third-party eavesdropper.
The old third-party argument.
Right, and yeah, we're seeing that seeing that often. Eric thinks it's terrible.
It's terrible. Terrible.
So they asserted that argument, but of course, this case is in California, and they relied on the decision in Javier versus Active Prospect, which stated that the Active Prospect Trusted Form is more akin to the eavesdropper versus a tape recorder.
So the third-party argument was rejected. What a
surprise,
surprise, because it's a terrible, terrible argument. So look, as we already covered, what the CIPA prevents is the real-time reading or attempting to learn the content of a communication that has to take place while it's in transit or as it's being sent or as it's being received. It doesn't matter if it's a third party that's doing it or not. What matters is someone doing something in real time? When you're talking about Active Prospect, great company, by the way, in Trusted Form, of course, the sponsor of the Troutman firm, now Troutman Amin 2023 annual TCPA review. We love these guys. They are not doing any analysis in real time. All they're doing is recording the communication. And guess what? 631, the wiretap provision, does not prohibit recording. And so why people are like running around like chickens with their head cut off, falling on the ground, arguing it was a third party, it was a third party, that doesn't matter. That's not even in the statute. What matters is the conduct that's being alleged. Recording isn't prohibited to begin with, guys. Like, open your eyes, make the correct argument. Very frustrating. It's just, it reminds me of the TCPA like 10, 15 years ago when all these lunatics were making these terrible, terrible arguments and creating bad case law that then my clients had to deal with, right? It's the same thing with CIPA. We've got all these clowns running out there doing these recycled arguments that don't even make sense. Nobody thinks for themselves, I tell you. That's the downside about the legal profession, right? There's very few lawyers that are actually out there innovating. Everybody else is just copycatting what they've seen before. And there's no thought, no independent thought is taking place. Proof is that people keep bringing this terrible third-party argument. So bad case law keeps getting developed because it's a bad argument, and these cases keep getting stronger and stronger. It's like the Marshmallow Man from Ghostbusters. I don't know why I pulled that one out of my hat, but like it's just like this huge like monster now, just like coming through the halls, and like no one can stop it. Of course, we've got the proper arguments. We've got some good cases that hopefully will create good case law that are coming down the road. But it's very frustrating. I hate to be unduly negative. Nobody likes a grumpy czar. I get it, but it's just very frustrating when I keep seeing this over and over again. But you're right. These CIPA cases continue. The third-party arguments, they're duds for the most part. And these web session recording cases, particularly the Active Prospect cases, it's just too bad because literally recording the very thing that they're doing is not even something that's prohibited by the statute to begin with. These cases should go away. Unlike, right, there's other cases like this OpenAI case, the idea of actual screen scraping or listening into chat communications where you've got third parties, for instance, that are enabling a chat box and they've got the ability in real time to listen in and do analytics. That's a horse of a different color, right? Those cases could have legs, so that is something to keep in mind. But anything else on that one?
That's it.
Fantastic. Okay, now I'm going to make a confession. Are you ready for my confession? I am very rusty. You know how I know that I'm rusty? Because I didn't even introduce at the top of our show that we've got guests today, right? And we have got two guests, and they're fantastic guests, and they're Frank Kearny and Tav Gomez of the consumer protection firm. These guys, previously of Morgan & Morgan, absolute sharks, swimming around with tails and dorsal fins and the whole thing out there. And they're going to tell you how currently they're doing FICRA cases, but I brought them on the show because they're moving into these state TCPA cases because they're highly enticed by the promise of private rights of action with large statutory damages and a framework where nobody knows about these laws yet, and they figure they can cash in. So now, through the power of Troutman Amin LLP, we bring you Frank Kearny and Tav Gomez. Enjoy. Welcome to the show, guys.
What's up, everybody? Thanks for having us.
Thanks for having us. We're excited.
Frank, I love the shirt.
So we've got Tab looking dapper and professional, and Frank, I take it is just like some goofball that you picked up off the street. Like, who is this guy?
First of all, I deserve to win as much as anybody else. This shirt makes me feel powerful. Like, I know I've got the best lawyers in the world behind me. This is a good feeling to have this shirt.
Well, Frank, you deserve to win. We'll get into this in a little bit, but I'm pretty sure you own TCPAWorld.com at one point.
Why would you just lead with that? Let these guys introduce themselves first. Tab, Frank, well, for the folks that don't know who you are, can you introduce yourself for our viewers?
All right, I'll start first. Tab Gomez. I'm a founding partner together with Frank of the Consumer Lawyers. We previous to this, we worked for Morgan & Morgan. I ran the orbit for the whole nation. We did massive TCPA. We loved it. I had the pleasure of being in Washington, D.C. with the team of Troutman, of course, and he's everything trying to see what ACA would do. And when we left there, I was like, I better find something else to do because this could go south. And at the federal level, it did. But we're blessed. We had a great practice. We had so many good experiences litigating those cases. We made a lot of good money. The TCPA at the federal level was so powerful. And then, we had the decision, unfortunately, of how the definition of an auto dialer occurred. And we'll get into that since we're going to talk about the Supreme Court. But we kind of took a step back, and Frank and I left Morgan & Morgan. We could have done a lot of money doing personal injury, but we love federal law. We just love it, and we love the consumer portion of it. And we moved into FCRA, the FCRA, and we have been pounding it. And we have a very successful practice. And now we're back into the TCPA, but we're in a different way. We're mostly doing sort of pre-recorded. It's the TCPA changed, so we're doing pre-recorded, maybe class actions nationwide, but more importantly, state-specific type of TCPA, but we'll get into that in a little bit. But we're very thankful to be here, and I'll let Frank now introduce himself.
Thanks. I'm Frank. Tab just told you everything about us. But no, we were doing TCPA over at Morgan & Morgan for a long time. We left. We're doing FCRA. Our practice is basically at this point almost entirely FCRA, although we recently just started running a campaign for a couple different states. It's a nationwide campaign, but we've got a big focus in Oklahoma, Washington, and West Virginia, trying to pick up on some of those new statutes that have passed. So we're sort of breaking back into the space, if you will.
Yeah, so thematically for our listeners, right, we've got Frank and Tab, he just told you, historically big TCPA players from Morgan & Morgan. They've moved on. They're doing FCRA, which we're going to talk about here in a second. But why I wanted to have you on the show is, Frank, what you just said. Like, you guys are making moves now back into the TCPA space, not at the federal level, but at the state level, which is something that I really want people to be paying attention to. So, Frank, if you want to tell me, or Tab, what's making the state mini TCPAs, like what makes that attractive to you guys to kind of come back into the telecom waters, if you will?
I mean, look, I told you this, and I'm going to say this again because it's undeniable and it is what it is, but legislatures are passing it. The statutory damages associated with these cases are obscene. You're looking at people that are getting massive paydays because they got a bunch of phone calls. And look, I don't write the laws, right? But I'm here to sue you if you break it, and that's what it is, man. So, it's a great thing for us. It's a great thing for our clients. But it's a huge windfall for people, right? Like I see on TCPAWorld all the time. People are getting a bunch of phone calls. They're bringing a lawsuit, and when you talk about people that are getting $1,500, $2,500, $15,000 for a phone call, it's outrageous. But it is what it is. It's what the legislatures are passing, and it's what we're here to do.
It's outrageous, so I'm going to cash in.
Well, I don't know if it's outrageous. It's fair. It is justice. It's not what was taken from you. That phone call took your happiness away. But I'm just messing with you. But listen, the main thing is this. We all learn, and this usually occurs, whenever you have a federal law that's controlling, and that federal law goes away, and it's a popular federal law, you have states jump in, and now you have a little bit of chaos. And we're located in Tampa, even though we do nationwide. Florida went great and it was amazing, and we were going to do it. But we have DeSantis, who's incredibly conservative. We have a conservative legislation, and now it switched back. There's other states, and again, this is where when we saw the TCPA and we saw it back in 2012, 14, 15, banks, debt collectors, lead generators, they didn't know how to handle it because they were not getting sued enough, and then it became a huge wave. It's the same thing now after ACA, after the Supreme Court's decisions, after all these things, people can lay back again. Now we're looking at it as like, FICRA is amazing, but I tell you what, you have a debt collector, or you have a lead generator, or you have pre-recorded messages, and they don't know how to monitor these campaigns because every state is now different. So we're looking at laws like the one passed in Oklahoma going, there's going to be lead generators, there's going to be, companies trying to market new commercial products or expand some products, and they're going to be making these mistakes because now there is a sort of an ambiance of that law is no longer, it doesn't have any teeth. And this is when you can maximize, this is when you can make sure that your consumers, receive what they are entitled to. This is when classes become good because everybody lays back because they hear it's no longer a national problem. And we go, okay, but it is now a local problem. And the people deciding these campaigns just lack enough knowledge regarding every state. There's states that say you can call more than 3 times in a day, regardless of the commercial purpose. There's states that go, you got to identify yourself. And this is where we're finding the weak links. And this is why, as good as FICRA is treating us, we're going, we will be fools not to expand our force and get these kind of cases and really explore them because the mistakes are being made. We see it because we're getting those calls already based on our background, based on all the TCPA we did. People are calling us going, they're making these mistakes. And I'm going, what? How are they doing this again? But it's beautiful.
I love it, Tab. I mean, look, that's exactly the lesson that people need to be learning, right? Is that at the state level right now, there's a lot of esoteric differences, there's nuances, and if they're not paying attention, guess what? You are, right? You're just sitting right there hoping these guys don't pay attention because that's just money ultimately in your pocket, and you guys are terrible people for that. No, I'm kidding. But actually, remarkably, looking back though on your history in the TCPA, one of the things that made you guys in particular uniquely dangerous, in my view, is that you didn't always rely on the threat of a class action to cash in big. You guys would bring individual suits and still deliver huge victories. I mean, you guys have verdicts in individual TCPA cases of over $250,000, like repeatedly. Can you talk a little bit about your history and kind of what your strategy is when you're pursuing these cases individually?
So we got so lucky insofar as Morgan & Morgan, a huge nationwide law firm, the biggest plaintiffs law firm, and I think they tout themselves as in the universe at this point, but they're gigantic, right? Like they've got 800 or 900 lawyers at this point, but they bifurcated their consumer practice and their class practice. So they wanted class action specialists and consumer specialists. Now we worked hand in hand, we might identify a case and give it to them, or we might help ghostwrite a motion for them or whatever. But, at the end of the day, they were two separate departments. Our job specifically was to bring the individual cases. And so, Tav and I laugh about it today. There was a point in 2015 when they started running the nationwide TV commercial that said, $1,500 a call. It doesn't matter if you owe money to the person, they still have to pay you. We had signed up at one point. What was it? 2,000 cases?
Almost 3,000.
3,000 cases we had signed up at one point with like a handful of lawyers. It was so crazy. But yeah, they're a huge monster. They decided to bifurcate those two areas. And so by nature, we became specialists in the individual cases. And it was amazing because we really got to litigate those cases against really good lawyers and really big law firms. And you guys specifically, we had a lot of cases with you back in the day. And man, those were great cases. But yeah, we got great results because we became pros in the law. We became scholars of TCPA land, or at the time, TCPAWorld today. We read every single case that came out. And, we really knew the law so well and so thoroughly. And that's our goal now, is to get back into it in that capacity. Like Tav says, we're doing really well with FICRA. I love FICRA. I think FICRA is the future because automation, it's only going to get crazier. But we know diversity is key in this practice area, and so we're reinvesting all the money we're making at this point now back into kind of local state robocall legislation, because that was our original love, right? So I'd love to be back really big in both spaces.
Yeah, and Eric, to expand on it, the biggest thing is the statutory damages per call, together with a strict liability. You got a beautiful case. So once again, once you go, you got to show me written consent. I mean, this sort of very few laws, and believe me, we've looked at it, and it's so funny. We go to these conferences and people talk to us about TILA and RESPA and FDUPT, and I'm going, what in the world? You're talking about strict liability per call, $500, and those are easily calculable damages, statutory damages. You know, in FCRA we deal with actual damages and emotional, and those are who knows what a jury's going to do. TCPA, why would we care about any emotional damages, any actual damages? I just want the statutory, 500 per call. You made a mistake, you repeatedly call, and again, a lot of this law is based on automation and computers, and computers have glitches and mistakes, and an individual can get called repeatedly from a lead that came in that was not properly filtered, and you got a great even individual case. So again, we are jumping back because we see and we know how to monetize and help our consumers, and that's what we're trying to do.
Okay, fair enough. So let's talk a little bit about FCRA. We've been throwing that acronym out quite a few times. You guys are big in the FCRA space. I know probably a lot of people who are tuning into this episode in particular are interested in kind of hearing from you guys in the FCRA side. What kind of FCRA, and I guess just to level set for the listener, FCRA is the Fair Credit Reporting Act. It's a federal statute. It's different than the TCPA. It looks at credit reporting. And it provides a private right of action to individuals who have been hurt or their credit report is inaccurate due to the negligence of either a furnisher of credit information or by the failure of the credit reporting agency to maintain procedures to assure maximum possible accuracy. These are the buzz languages out of 1681S of the FCRA. And of course, I know everything about that statute as well as the TCPA because I'm the czar. But in seriousness, what kinds of cases are you guys bringing? Are you focusing mostly on the CRAs and failing to maintain proper policies? Or are you looking at the furnishers who are providing inaccurate information and failing to do reasonable reinvestigations?
Yeah, so it's both. So almost every case is against both. Not every single case, but 95, 96% are probably against both the furnisher and then the bureaus that are then in turn reporting the information. What we're seeing a lot of, I would say probably, and Tav can correct me if he thinks I'm wrong, but I would say probably 75% of our practice is identity theft. So someone comes to us and says, you know, my identity has been stolen and I have 3 accounts I know nothing about. There's probably a solid, 20% of that, or 20% of the remaining cases that are mixed credit files. So 2 individuals named Frank Kearny, and they've been mixed up. Funny enough, my dad has I wish I could show it to you. My dad has been an American Express cardholder since 1983. I was born in 1984. My Amex on the front of it, I can show it to you. My Amex says card member since 1983. That ain't me. They've got me mixed up with him, for real. No, I don't care because it helps me because my credit history is going back to 1983 and my dad pays his bills, so I'm a lucky guy. But like, if you were someone else and your dad didn't pay his bills, that's a problem, right? And it's crazy, but like I do this all day, every day, and I've got that going on with me. So that's just one example. So mixed files are probably 20%. The other 5%, they're not the cases we love. They're not what we focus on, but they're like the status cases. Like, it is my account, and they're saying I was 30 days past due, but I've made the payment on the 29th day, and they didn't get it or whatever. Like, those aren't great cases, but the vast majority are identity theft, mixed files.
Yeah, and to follow up on that, this is why the FCRA is so good. The FCRA is the TCPA in 2008. Again, the TCPA was around since 1991. Nothing happened. 2005, somebody starts looking at it. 2008 starts to catch heat. 2012 is insane. 2015, the FCC sends that order. I cried. I go, what is the catch with this? This is insane. And then 2018, it starts to simmer. The FCRA is the same type of thing, but we are back in 2008. The CRAs, which are the credit reporting agencies, Equifax, XP, and TransUnion, are making so much money, and they're not getting sued enough. Meaning, there might have been 4,800 federal lawsuits last year nationwide in the federal level. That is nothing for the size of these companies. And honestly, the language you described, you have to have possible policies to ensure possible maximum accuracy. I mean, again, these are the words that really thrive on a jury, on a even an arbitrator, because they're so powerful. Maximum possible accuracy. It doesn't say try to get it right. So again, this is a law where honestly, clients come to us. Identity theft is the new crime. So again, we talked about it before, but nobody's breaking into houses and stealing TVs, because TVs are $200 and $300 at Walmart now. And so that is gone. The big crime is steal somebody's identity, max it out, and then take out your goods and be done. So this shows a pattern that it should be easily detectable by furnishers. And then when an individual has a credit report, perfect paying history, but this one account from a furnisher that goes open, max, never paid, always late, it should tell them something. So FICRA is amazing because it is the future of consumer law. We love it. It is exciting. It is, part of the portion with the TCPA is judges became insensitive to damages because they go, back when you could sue like a bank or a debt collector, they would be like, you owe this money. You kind of deadbeat it on the money, and now you want all these enormous payout. In the CRA, in the FCRA, the difference is judges have credit reports, jurors have credit reports, everybody has credit reports, and everybody can understand. If you look at your app and it says whatever bank, Chase or Bank of America, and he goes, my credit score dropped 70 points. Any normal person goes, what in the world? They're upset. These are real damages. It doesn't mean you have to go and try to buy a home. Those are the cases we love, but the industry is built to expedite things. So because we live in a society of now, I want immediate. This is why TikTok is huge. You know why? I only want a 15-second video. The 30-second is too much. This is like the 7-second abs from that movie back in the day, Something About Mary. Probably nobody knows that, but it's literally that. I want my results now. And when you have a mortgage commercial like Rocket Mortgage, we'll pre-approve you in 5 minutes. We love it because we go the amount of mistakes being made to rush. It used to be that you used to have to go, it would take 30 days. You had an underwriter, you had a million things. You can get qualified now, and your interest rate will be affected by that one debt that was not yours. And we're talking about credit reports, but it also affects your background reports. You could be denied housing, you can be denied employment, and those are gold because the damages, they're immediate. I apply for a job, it says there's a Tav Gomez in California that got arrested, and I get either denied the job, or now I'm so embarrassed with my manager and the people I interviewed. They're huge cases.
Let me tell you a really quick, just great example of why these cases are so good. I have a client right now who called me earlier today. She's got a mixed file with someone with the same name where they're reporting her as deceased. And the furnisher is a huge nationwide bank that everybody in America knows, and they think she's deceased. She called them today and did a direct dispute, which is not actionable under FICRA, but she's calling into them to try to fix the problem because she's upset about it because she doesn't want her credit to be jacked up. She called them today to try to get it fixed, and the agent told her, well, ma'am, the only way that I can remove the deceased notation is if you get the Social Security Administration to tell me that you're not deceased. Now think about what she's saying. You're telling somebody, yeah, like I get it, you're alive and you're talking to me, but like I can't do anything about it unless you get a government agency to give me a letter. What are you telling me that for? You're talking to me about my account because you know it's me because I verified all my information. It's the most outrageous thing. And by the way, I sent the spoliation letter out before I got on this because I want to have that recording because it's preposterous. Like you can't tell me that that's your policy, that's what needs to be done. Someone's being reported as deceased. Think how crazy that is.
Look, if you're talking to a dead person, you really got to get some credentials, right? I mean, 'cause that's just creepy. Let's be real. I'm gonna side with the furniture credit on that one. Like you just can't trust these ghosts these days. Like you gotta get this verified from a third party like the government.
It could be AI talking.
It could be that too. We're all gonna be living on beyond the grave these days. All right, guys. Well, look, I love the work that you're doing on FICRA. I mean, I really do. Are there any pointers that you can give folks from a FICRA perspective? Like if you're a furnisher or if you're a CRA, I know there's only like a handful of these guys. I mean, you guys know that the name of our podcast is Deserve to Win. And we always like to kind of give some pointers from the mouth of the consumer lawyers, right? From your perspective, right? Like what can a furnisher or credit, a bank or a servicing company, or what could a credit reporting agency, what do they do to deserve to win? Like what kinds of enhancements would you recommend? Would you say, look, if I heard that the company was doing X, Y, or Z, maybe I wouldn't want to bring that case because they're doing things the right way.
I have a great example, and I thought about this today because I was dealing with someone who got one of these letters. One of the smartest things that furnishers are doing right now is when they get a complaint of identity theft, they send their own little specialized identity theft packet. Now, none of that is regulated or governed by FICRA specifically. In order for there to be liability against the furnisher under FICRA, generally speaking, there needs to be a dispute to the credit reporting agencies first. What a lot of smart furnishers are doing really is when they get a call from you, because the first thing you do when you've got a mistake is you don't call Experian or Equifax, you call the credit grantor and say like, that's not me, or you're wrong, or whatever, right? So when you call the furnisher, what a lot of them are doing now is sending their own little individualized packet for you to fill out that says like, oh yeah, we can fix this for you. Here's what we need from you to do. They're still not necessarily doing anything, but what they're doing is in one way, they're exhausting the consumer who's going to like jump through a million hoops to try to get this fixed. And if it gets fixed, great, then there's no problem. If it doesn't get fixed, there's no liability against them still, right? They still haven't done a dispute to the credit reporting agency. And when I say they've exhausted them, like, a lot of these people, we always talk about like the standard of like the least sophisticated consumer, which in credit reporting, you're talking about usually pretty sophisticated people because they care about their credit score. But generally speaking, still, if you're talking about the least sophisticated consumer, people don't have time for this, man. They work difficult jobs. They're stressed out. For them to go get all these documents, run to FedEx and get copies and fax it and all that, it's exhausting. A lot of people are going, you know what, I did all that and it didn't fix my problem. I'm over it. I'll just live with it. It's not a big deal to me. So that to me, I would implement a policy. If I was the in-house guy, I would send the most thorough, detailed letter like, here's what we need from you, with a million stupid things for people to jump through, because truthfully, why not? And one, it might work and it might fix the problem. But two, you might also deter somebody from chasing the problem down to fix it, right? And you might absolve yourself of liability. So to me, that's $1 million of free advice from Frank Kearny. You're welcome, everybody.
Send the consumer on a wild goose chase. Got it. Good advice. Tab, do you have anything?
Without that, I think one of the biggest things, and again, this is, and I'm an honest guy, so I'll say it. FICRA is not big enough for the furnishers and for the CRAs. They're not getting hit hard enough with litigation. And look, anybody who represents, a bank, a lead generator, anything like that knows that the industry changes as your ratio of how much are you spending dealing with this problem. It's a cost of doing business. Right now, the most beautiful thing from the plaintiff side is this. The FICRA portion is completely separated from every other portion of the industry itself. And what I mean by that is they have most furnishers, honestly, most furnishers in all CRAs, not one, all CRAs have foreign vendors. Those foreign vendors don't have access to accountants, don't have access to recordings, don't have access because they're trying to minimize the costs. So most furnishers and all CRAs have vendors abroad who have no access to the full records. Of course, they'll have access to, when they get an ACDV, which is the complaint from the credit reporting agencies, they have a self-populating match name, date of birth, social security. They have access to that. They don't have the ability to contact the consumer. They don't have the ability to listen to recordings. They don't have the ability, most of the time, to look at account notes. They don't have the ability to look at documents because this is most likely a vendor in a separate country where you're going, I'm not risking that kind of liability for the data breach I just want to pretend like I'm compliant, despite the fact that the policies are written for us. But that's the biggest thing. If they were able to incorporate and allow, maybe get a US based type of dispute investigator agency or vendor, but if you allow them to be able to see some of your records, we get this nonstop. And I'm telling you, look at the biggest banks in America. When you get an HCDV, which is the dispute went to a CRA and it came to you, that's not included within the account notes. It's insane because it goes to a vendor and they just do all the work. So we go, well, how is it reasonable? How is it a reasonable investigation? Well, we compare our own data to the data that was provided. And no, but you don't allow them to Google. You cannot send an email. You cannot call the consumers. These are all things that every furniture and every single CRA does. They're just not allowed. If you get that in front of a jury, and our anticipation is going to try the case in the next 6 months, it's going to be exactly that. You're trying to collect the data. Why in the world can that dispute investigator not go, I'm not clear about what you're disputing. Why not pick up that phone? Well, they're in India. They're 12 hours away. Well, okay. They're in the Philippines. Okay. Like that is a huge problem for the industry. But again, it won't change until we hit them enough. And that's our goal, to change it. The TCPA changed because the lawsuits got so big, the class actions got so big. And again, everybody, within America and our culture, they go, oh, plaintiff lawyers, especially class lawyers, they're greedy, they're this. Yeah, I understand that in the individual level, most of the class members are getting little money. Most of the money goes to the class attorney. But I got to tell you, it changes the culture. The TCPA, and you might not agree, Eric and team, but I'm going to tell you this. The TCPA changed because of lawsuits. It did. And also going to litigation. The FCRA is about to go again, but the FCRA has gone before to the Supreme Court. But again, as we continue to prosecute these cases, it becomes more relevant and it becomes, it changes the industry. It's just not there. That's why we love it. It's 2008 FCRA, it's 2008 TCPA.
Yeah, it's really fascinating because, again, the furnishers do have the responsibility to do reinvestigations. It does beg the question, right? If these vendors that are responsible for doing the reinvestigation have actually no access to the consumer records, what exactly are they doing that's reasonable? It's a really good question. I agree with you, Tab. There does seem to be an opportunity for change here that the FCRA litigation might drive. Now, let's pivot back to where we started the show, which I know what Pooja really wants to talk about, is this thing called TCPAWorld. I'll set the table just real quick, and I'll let probably Pooja run with this, and Frank, I know you two are going to giggle about it, and that's fine. I accept this. So there was as everyone knows, TCPAWorld, probably the best read legal blog other than like an Above the Law or a SCOTUS blog. Certainly the best read telecom blog out there, no question about it, followed by regulators, the FCC, the FTC, Congress, staffers, really everybody out there that's even remotely interested in telecom law, of course, follows TCPAWorld. And we almost never had TCPAWorld, and we wouldn't have if it wasn't for a greasy dollar fished out of somebody's purse at a barbecue restaurant in Memphis, Tennessee. And with that set up, I'll let Pooja and Frank kind of take this on. Like, talk about however you guys want.
Frank, you want to tell us who owned TCPAWorld.com before I did?
Listen, I'm just a grimy kid from New Jersey, and I was born a hustler. So when I see an opportunity to make $1, whether it's outrageous statutory damages or ripping off some fancy rich lawyer in Los Angeles, I make my buck, my man. It is what it is. So I knew Eric had this amazing website. We were fascinated by it. We thought it was brilliant. We were students of the TCPA, and we tried cases with you guys and your whole team. And honestly, I'll tell you, swear to God, this is true. He might get mad at me for telling you this story, but we were in a mediation in North Carolina. Eric, you know where we were, in those big towers out there in Charlotte, and the mediator was the former Chief Justice of the North Carolina Supreme Court. A very impressive guy. And when you gave your opening, Tav gave his opening, you gave your opening, and he left the room and he started with you guys. We broke the caucus. He came back in and he goes to me and Tav, that other lawyer in the other room is a platinum lawyer. And me and Tav were like, shit.
Are you allowed to curse in this podcast? I don't know if you are, but yes.
They got a rock and roll T-shirt, man. This is rock and roll. So, so we were like, oh my god. So then, anyway, point is, fast forward, Tav and I are talking, and I'm like, man, we haven't tried one of these TCPA cases yet. We want to try one. Like, we really want to. And I'm like, we got to pick like who we want to try to get to be the first one we get to do. It didn't get to be you, unfortunately. But Tav said to me at the time, I want to try it against our boy, the platinum guy. And I go, no, not the platinum guy. We don't want the platinum guy. What do you mean? But, you know, Tav's like that. He likes to try to be the best. You got to beat the best, right? Anyway, point of this whole thing is we were big students and we followed everything you did. We read everything you did. So you kind of, I read the writing on the walls, whatever, with your situation. And I saw your old blog and I go, man, it would be funny if I bought the domain, not land, but world, right? Because that's like the next bigger, better thing. So I did. And then, of course, it all kind of came to fruition when I found out you might have needed a new domain. And of course, I sold it to you guys for a very reasonable price. I didn't ask for $1,000, man, $1 at a barbecue place. I'm not fancy.
No, so yeah, I feel like we gotta set the stage. I mean, thank you for all of that. And yes, I am the platinum lawyer. I know exactly what we're referring to, and I think we just violated the mediation confidentiality rule, but whatever.
That part isn't confidential.
So it came to pass that the beta version of TCPAWorld is a different domain. And despite some contractual agreements I had with the previous firm, they decided they were just going to go ahead and hold on to that and torpedo it, and that's water under the bridge. But the bottom line is I needed a new website, and we were sitting together at a Memphis barbecue joint. Literally, like I was crying. Well, not literally crying, but basically crying into my beer and into my ribs. Like I had this great website and now it's gone. And Frank looks up with like the wryest, like deadpan, and he's like, "Well, I know a guy that owns TCPAWorld.com," and I was like, "What?" And he's like, "I own TCPAWorld.com." He breaks into this big, proud smile, right? Like an 11-year-old kid that like just caught a fish or something. Like he was so happy, he was so proud of himself. And he's like, "And I'll sell it to you, but it's gonna cost you." And I just thought to myself, "Oh, here we go." But you know what? At the same time, I was applauding it. I was like, you know what? This is capitalism at its finest. Well done, sir. Right? Well done. I applaud you. And then what he did next was shocking. It was absolutely shocking. He literally said, and the price for this website is $1. $1. And so, although he could have charged the moon, the stars, and the sun, I would have had to pay it. He gave me the TCPAWorld.com domain that you all now know and love for $1. And of course, this is Pooja's point, is because I, living in a cashless society, I did not have $1 on me in cash money. And, at that time, Frank was like, "No, I'm not taking Zelle. I don't have a Stripe on me. I'm not doing Square. I need $1 in cash." And of course, Queenie comes to the rescue and fishes out in her giant Louis Vuitton spiked purse, goes through and finds like a crumpled dollar bill underneath like the mascara and the Bic and the Maybelline, whatever else she's got in there. And she hands it over, and Frank, true to his word, very quickly thereafter transfers the rights to the website over to me. Although Pooja claims that she is now the owner, right, of equitable interest in the website as a result. So.
And invariably, when this video comes in a deposition now, she is the owner of the website. But also, I will just clarify, initially she pulled out a wad of hundreds and said, "Do you have change for this?" She had to actually go to the bar and get change to give me the $1, but yes.
Actually, that's the most Pooja thing I've heard today. I'm not sure I remember quite that way. I was still leaping into my tea. So Frank, thank you very much, though. Honestly, you changed the course of TCPA world history. And thank you both for being on the show today. You guys are fantastic guests. And although I am heartbroken to hear that you are moving into state TCPA litigation, I guess not from a certain perspective, I'm looking forward to going toe to toe against you guys again. You're great. Great lawyers, highly competitive lawyers, very sharp, and people shouldn't get the wrong impression, based on Frank wearing my T-shirt. These guys are killers. They're gonna be taken very seriously.
I paid $39.99 just like every other consumer that has one of these.
All right.
No, we greatly appreciate it, and I wanted to tell you, Eric. So the reason why, when you got now TCPA World, it serves so much purpose. It educates everybody. Plaintiff lawyers, they all follow And this is, I wish there was an FCRA class, a FICRA, website just like that. Because I'm telling you, you do a lot of funny things, you do all these posts, but you educate. And, and I remember when we were doing TCPA, we were keeping scorecards, and you would be like, this is the, TAB Gomez or Morgan & Morgan scorecard. This is our scorecards regarding how cases were going. But it educated everybody. And it educated, the defendants, and it educated plaintiffs' lawyers. And this is why it's so important. And we don't have that in FICRA. There's not one website. You get little, Google alerts that don't mean anything. I hope you move into that world. I hope you get FICRA world. And, because I'm telling you, this website and the content and what you guys are doing and everything that you do is entertaining, but it is educational, and it helps everybody. It helps an arbitrator who's having a private arbitration. They can go back and look and read objective. And you one of the best things you've done, you're not afraid to report the bad verdicts. The problem with 99% of websites that do what you do is they're always cheerleaders. They're going, hey, we won. Hey, look, one case in Wisconsin. And they forget the 7 cases that came out in North Carolina, Florida, everywhere else. When the mini TCPA came out in Florida, you were like, this is trouble. You were not afraid to go, hey, DeSantis put this through. Hey, crushed it. So that's the difference. And that's what has made your side different than all the other sides, is you actually, even though you're clearly defense and you think you're a lion doing defense with Pooja and your team, I'm telling you this, you're not afraid to say the other side. And that's what makes it the most honest, best website for legal research, because you're objective for the most part. You're opinionated, but you're not afraid to demonstrate when a plaintiff is successful. And whether you think this is a terrible ruling, the judge is completely wrong, but you report it. That's not what people do. They don't do that when they file their motions for summary judgment, even though it's sanctionable, and they ignore case law that is relevant. You don't even do that. You take the ethics of writing motions and being able to describe both sides, and you put it into your website. And that's remarkable. That's why we love it. And that's why we still come into your site, because it's remarkable. So keep doing that.
I appreciate it, Tab. Well, look, I take my journalistic integrity very seriously, and I really do. Look, I express my opinion, and you're right. I am defense-oriented both by profession and by philosophy. But at the end of the day, I'm not doing anyone a service if I'm not shedding both sides of the story, if I'm not sharing information that's good and bad for the folks that are gathering it. And to be honest with you, in many instances, the damaging information is actually more educational. It's actually more valuable for my reader, even if they don't want to read it, even if they don't want to see the horrible ruling that just came out. Like, that's what they need in order to keep themselves safe and to deserve to win, right? That's what we're all about here, is putting people in a position to be successful when they come across, guys like you. But we've run a little long here. Tab, you said you were only giving me 20 minutes, and now we're at like 45. I'll
send you the bill.
I appreciate that. Thank you guys so much for being on the show. You've been great guests. Big round of applause.
Thanks, guys.
Thank you.
Wow. I got to say, I always love hanging out with Frank and Tab. They had quite a bit of energy today, I would say. I really enjoyed that. Let's throw it around, see what everyone thought. Tori, why don't we start with you, the dame?
Well, this is my first time having the pleasure of meeting Frank and Tab, and it was very interesting hearing about, what they do and, the TCPAWorld story. it feels like, a great origin story for that.
What did you think about me being referred to as?
I totally agree.
I have one thing to think. What comes to mind is platinum card, like top tier. Exactly.
I'm an expensive fella, I guess. So throwing it over to you, Brittany, the Baroness. What did you think?
A few things. First, love the shirt. I thought
that was great. He's
very supportive. It totally fit his vibe too.
Yeah.
I really like that. Two, I think it's really cool how they're getting into the state TCPA stuff. We don't hear too many plaintiffs' attorneys kind of really going after that, so I think that is pretty cool.
Well, that's why we brought them on, is because I think canary in the coal mine is the wrong phrase, but they're like a weather vane, right? Mm-hmm. And that's what, to me, this is what makes this show interesting. So we bring the plaintiffs' lawyers on, we just ask them what are you into, what are you moving toward, and they kind of give you directionally what they think is important, which should help everybody out there to understand. If these sophisticated lawyers who literally, their ability to buy boats and houses and cars and airplanes turns on picking the right cases, and they think the right cases are mini state TCPA cases, I mean, that's something you got to keep in mind, right?
Right, and it's good for us to know as well on the defense side to be aware of those state mini TCPA laws and not just focus on the federal statute.
Yeah, I mean, there's been a ton of that activity lately, obviously, as we talked about earlier in the show, Pooja covering Connecticut and other things. Yeah, well, fantastic. Anything else?
No, that's it.
Pooja, my partner. I'm still getting used to the Troutman Amin thing, as you can tell. But I mean, honestly, like we've been doing this now together since May 1st. You've been my partner. It is now, as the crow flies, what, July? We're in July. So it's been 2 months. We've been doing it for 2 months.
Wow.
I don't know, I think it's going pretty well. What do you think on the firm overall and then on what you just saw?
Well, realistically, we've been tangoing for ever since we knew Frank and Tav.
I don't
right?
tango. I don't know how to tango.
So, really, we've been working ever since, I was first introduced to Tav and Gomez on the other side as opposing counsel. And listen, I've seen Eric and Tav go head on numerous times, and Tav and Frank aren't folks to be messed with. They may seem a little fun and a little bit goofy at times, but arguably, Tav may have been one of the best TCPA plaintiffs attorneys out there at that time, and so it won't surprise me as they continue to pick up more of these mini TCPA laws, and if we see them on the other side, that we're really, really going to have to button up and get ready for what they're going to bring. They're exceptional attorneys. I respect them from leaving the big plaintiffs firm and going and starting their own firm, but they're doing extremely well, just the two of them too, as many of these plaintiffs attorneys do. But I've been speaking a lot and making a lot of noise out of these mini TCPA statutes that are coming out. We just talked about it earlier with Connecticut, Oklahoma, and FITSA still going strong as well. So you just got to be careful, right? You got to make note of what these folks are looking after. They're always looking for the next thing. They're always arguably a little bit ahead of us because they need to know what their next target is.
No one's ahead of me. Let's be real. Let's be real. No one's ahead of the czar. But keep going.
Well, by ahead of us, they know what their next moves are going to be as far as filing these cases, right? We won't know what's coming until those cases are filed and what happens to our clients. They already have it in the back of the mind. I suspect as soon as FITSA was amended, a lot of these plaintiffs' attorneys had already started pivoting to the next state. And you heard Tav say, he didn't get into FITSA because he had a feeling that it was going to get amended. Not the same case with Oklahoma. So these folks are thinking about that. So just something to keep in mind.
Yeah, no, these guys, they're sharp. I mean, what I took away, a couple of things I took away. Look, every law firm out there, other than Troutman Amin, is reactive to some degree, right? We try to be proactive. We try to be ahead of the curve. I look into the future and try to see what's next. And then I talk to the opposing counsel. As you can tell, I try to have good relationships, even if we do battle. I try to have good relationships with everybody on the other side because I want them to tell me, I want them to be my weather vane, what's happening next, right? So that I know not what's happening today. Obviously on TCPAWorld, we break down everything that's happening today. We're on top of that, but I want to know what's happening next. And when guys like Frank and Tav are pivoting over to state mini TCPAs, and you heard them, they were practically licking their chops, right? Strict liability, no one knows about it yet. It was like, you could see the cartoon dollar signs in their eyes, the gleams in their eyes as they were talking about this. This is like the ultimate dream for a plaintiff's lawyer, is to have high value targets out there who are uneducated about the law. That is literally why we exist, to try to prevent there being those targets, to give everyone information for free. How much did you pay to watch this podcast? $0, right? It's all free. And we give it to you because we want you to be informed and empowered to prevent these gotcha lawsuits that result in these obscene rulings that these guys get. And look, I like them well enough, right? So on the one hand, I say they're pretty cool guys. On the other side, I call them, basically scumbags that are out there trying to predate on people. That's not a word, by the way. Predators who are looking for people who are not knowledgeable on the law. And we're trying to put an end to that. So I know it's a little bit of a dichotomy there, but at the end of the day, right, we are on the side of truth. And the truth is, you need to be complying with these laws. And if you're not, then guys like Frank and Tav, who are opportunistic, they are capable, they are aggressive, and they are motivated, they're going to come and they're going to find you, and they're going to bring these lawsuits. And there's not going to be a whole lot that even the powerful firm like Troutman Amin can do about it. That's a lie. There's always plenty that we can do about it. But thank you guys so much for tuning in to our 13th edition of Deserve to Win. Of course, our first edition as Troutman Amin. Really exciting. Hopefully you enjoyed our new studio setup. we're going to be finagling things the next few weeks. We might look different. We're trying to figure out what's going to be best in our new space. But as always, we really appreciate you being here. Thank you so much, and we'll see you next time.